This is Dennis Sullivan. Today I'd like to talk to you about whether you can be held responsible for paying alimony to your spouse in Texas from a Texas divorce. Texas does have a statutory provision which allows one spouse to receive payments from the other. In some states, these payments could be called alimony. In Texas, however, they are called spousal maintenance. Spousal maintenance is not favored in Texas. For your spouse to receive maintenance, a number of factors must be proven. Your spouse can receive spousal maintenance if the spouse cannot provide for their own minimum needs. If your spouse is able to show that they cannot meet their minimum needs with the resources they have, the court will consider awarding spousal maintenance. In order to receive spousal maintenance, your spouse will have to show that either you have been convicted of a family violence offense, or that your spouse is physically or mentally incapacitated, or y'all have been married for at least 10 years and your spouse is incapable of earning a sufficient income, or your spouse cares for a disabled child and as a result is unable to earn a sufficient income. The court's determination is not over, however, upon the answering of these questions. The court will then determine what maintenance is due. The court will take numerous factors into account when determining the amount of maintenance owed. These include each spouse's ability to earn income, the educational levels of the spouses, including whether one spouse assisted in putting the other through school, how long the marriage lasted, the physical and mental conditions of the spouses, whether one spouse fraudulently disposed of marital assets, or whether one spouse engaged in abnormal expenditures of the assets. There are a number of factors in addition to these that the court will look at, but these are just a few of them. The court will presume that spousal maintenance is not warranted unless the opposing spouse has attempted to earn sufficient income or undergone some training or education in order to do so. The duration of the maintenance order is limited by law. It cannot be for more than 10 years, depending on how long the marriage lasted. But, as you can expect, there are some exceptions to this limitation based on compelling needs of the spouses. The defense against a request for spousal maintenance requires both factual and legal arguments. You will need to prove your spouse is not entitled to maintenance and that your spouse has the ability to meet their minimum needs. You will want to argue that your spouse has not taken those steps necessary in order to earn a sufficient income. The court does limit spousal support, however, to $5,000 per month, but again, there are some exceptions and clarifications to this general limitation. In order to fully protect you and your rights, you need to contact an experienced Texas attorney. The attorneys at Stepp Sullivan are those attorneys. Stepp Sullivan can assist you in navigating the factual and legal requirements of Texas spousal maintenance. The lawyers at Stepp Sullivan are here to help you with any family legal issues you have. We are more than happy to meet in person, observing social distancing guidelines, by Zoom, by Skype, or simply over the telephone. If we can answer any questions you have, or if you need additional information, we're here for you. We work one-on-one with our clients to focus on the outcomes that are most important to you. At Stepp Sullivan, we make it personal, powerful,